Today was a good day, as Ice Cube would say. Today was a good day for the mayor in Mexico Beach, Michelle Miller. You'll recall she defeated incumbent Al Cathy, the longtime mayor and owner of Ace Hardware. He was the mayor, and he was being paid by the city more than $500,000 while he was the mayor. Sheriff Tommy Ford doesn't find that to be a problem, and so far, neither does the FBI. But the Joint Legislative Auditing Committee, JLAC, they're very concerned about what's been going on in Mexico Beach. The last 2 years, audits have been canceled, have not been performed. After the city got $100 million in FEMA money, I am hearing that the state legislature or somebody higher than State Representative Griff Griffiths and State Senator Jay Trumbull, somebody higher than that, I am hearing, is putting a hold on FEMA reimbursements, just like they're doing in Washington County. Ooh, Mexico Beach. No wonder, by the way. No wonder everybody's jumping ship. Remember when these guys jumped ship and they said it's because the mayor is too mean? Michelle Miller, Mayor Meany, was too much to handle. So you had Doug Baber, who had the key to the bank, the only guy with the key to the bank, and his protege there, Michael Manning. They took off. They went down to, they jumped ship and they went all the way down to Crystal River. They said they got a better job at Crystal River after accusations were flying that they were bid rigging in Mexico Beach and denying the CFO, Mayor Miller, access to the city's finances, which was a red flag. So they got a better job a few months ago down in Crystal River. Only this happened. Soon afterward, they both abruptly quit Crystal River after what? Ding, ding, ding. Accusations that they were bid rigging there as well. So you should have seen what all of the staff said about these two jokers right here. And you had all those people in Mexico Beach. Doug Baber's so great. Oh, Michael Manning, the mayor's too mean. Well, guess what else? Now a council member has resigned. Adrian Welly. I wasn't going to mention this. You say, Bernie, he didn't resign. Okay. Now, he's not going to be at the last couple meetings, the special meetings, like 4 meetings, but he didn't resign. He left. He had some health issues. He brought it up, and I'm not going to go into it. I hope that Adrian Welly gets well and is not too sick, and I mean that. But Adrian Welly said, I got to get out of here. I got to go back to Minnesota. Only one problem. He's being subpoenaed for the hearing here. He's a witness for the recall committee lawsuit and the other one, because Adrian Welly, who knows more about the city's finances than anybody, I know because he said so over and over. He used to be the finance director, and I think he might have even been the city administrator. All I know is Adrian Welly knows more than anybody because he said so. And so he would be the first one I'd question, and he's going to get his chance to answer questions under oath and tell everybody how dumb they are. Because one time he said, boy, if you ever did see the finances, it'd be boring. Evidently not too boring, because the FEMA consultant, he quit too. Yeah, Ryan with Atkins, he quit. I think he's living in Europe now. So basically the only 2 people left are Iron Fist, the vice mayor, Rich Wolf, and old bad liability, Jerry Smith. These are the only 2 guys left. Mayor Miller's run everybody out, Mayor Meany. So they had a recall committee. Do you remember the recall committee? They said she committed a sunshine violation again, and she fired a contractor, and she had another contractor go and look at the finances unilaterally on her own, exceeding authority, violating a statute. We're going to take a look at that because the recall committee responded to Mayor Miller, who filed a lawsuit against them, being represented by Marie Maddox, the great lawyer out of Tallahassee. And she filed a lawsuit against them. So you can't just make stuff up and recall elected officials that the voters chose. You can't just make stuff up now, because they claimed she had committed malfeasance and misfeasance. Yeah. Only problem is they didn't have any. I'm thinking of a word. I'm reaching for a word. Oh, I know. Evidence. Then there's that. And the recall committee told the judge, Judge Goodman, here in Bay County, they said, Your Honor, you don't have the authority to decide whether or not the basis for the recall is valid. That's up to the voters. Only today, and Judge Goodman, I listened to the hearing last time, and Judge Goodman said, well, I don't want to be put in a position to stop an election, recall election, but I'm going to have to see the arguments from both sides. And we're up against the clock. Geez, the early voting starts on the 8th, and mail-in voting may have already started. So Judge Goodman was not happy, saying, you guys have really put us up against this with these late hearings. Now, that was actually a function. I think Judge Goodman thought that it was Mayor Miller's side that was dragging its feet. But of course, it was the recall committee's side dragging its feet, because they figured if they could just get past it to the point where the election was taking place, well, then the lawsuit, wouldn't affect it. Well, today, Judge Goodman filed a ruling denying the recall committee, the defendants, motion to dismiss. And I'm going to read to you what the grounds are. But first I want to refresh what WMBB has been reporting about the mayor of Mexico Beach being recalled. You remember all that? Yeah, let me refresh your memory. Tom Lewis, the news director, Huey Lewis in the news, Panhandle Strong. He was pushing this narrative. You know Tom Lewis.
In Panama City Beach, I'm Tom Lewis, News 13, Panhandle Strong.
I'm going to show you that news story right after this.
Strong, effective leadership. 3 words that could mean the difference between prison and your freedom. I'm Al Saleen, your Panama City Beach lawyer. 850-215-0628.
Don't let back pain and neck pain get you down. Find relief at Brown Chiropractic Center on St. Andrews Boulevard in Panama City. Dr. Sherry Brown helps people heal naturally with chiropractic adjustments and deep tissue massage. Call 769-3777. All right. Hey, I gotta show you something. Do you remember the show last night when I showed you that the Panama City Beach mayor, Mark Money Mover Sheldon, he debated his opponent, the candidate who got an incredible campaign going, Stuart Tetimer, who wants to put locals first finally in Panama City Beach, and Mayor Mark Sheldon. He was saying, no, we got to put migrants first. We need to build more hotels so we can have affordable housing for the visa workers, right? For the big developers. That's the priority here. Okay. And they're going to be lifelong residents here. He said, I'm all for them being lifelong residents. This is good. This is their home, which got me wondering, are they going to be voting at some point? I mean, this is their home. If it's their home, they can vote. It's kind of like New York. So I'll show you. I made this. This is absolutely unbelievable. But Mayor Mark Sheldon is running on the platform to put migrant workers first. He says, we're moving forward together. And he growls and moves his shoulder up and down. Moving Panama City Beach forward together. Yeah. How do you like that? So that's quite a race. You got to admit, that's quite a race. All right. We're getting to the story. Yeah, you got one guy running for migrant workers first and the other guy running for locals first. Let's see how that goes. I cannot believe what's going on around here. But today there was good news. And I'll tell you all about that after we are refreshed on WMBB and how they reported. You're going to see the chairman of the recall committee, who will be a witness. By the way, you might want to mark your calendars. Mark your calendars for April 8th. Because in the Bay County Courthouse, in Judge Goodman's courtroom, there will be two hearings. Both of them are the lawsuits filed by Michelle Miller, Mayor Miller, one against the city for violating the charter, preventing her as the CFO and the mayor from seeing the city's finances after the city is in a financial crisis to the point that the legislature has sent the auditor general, and they're rifling through drawers, looking under chairs and phones. They're doing a hell of an audit in Mexico Beach, and what they're finding out, pobrecito. No wonder everybody's leaving. But they'll get a chance to come under oath, and you can see it. So there's going to be that hearing, and then Judge Goodman is also the judge for the second lawsuit against the recall committee, and that's open to the public. I'll be reporting on that. I'll be there. I can't wait to see these guys under oath. I don't know if Adrian Welly, who has left the council a little early, decided he's not going to run again. And he's out of here. He's going to Minnesota. Said he needs a little time to just relax. I don't know if he's going to be testifying by Zoom or if he's going to be there in person. I don't know. We'll find out. But here's how WMBB reported about the recall of Mayor Michelle Miller.
Petition to recall Mayor Michelle Miller.
In the petition, the committee members claim that Michelle Miller violated the Sunshine Law and exceeded her authority as Mexico Beach's mayor.
Hey, do you think they did any investigating into that? Do you think that the news actually looked into what are the two allegations against her, and where is the evidence to show us where they did it? And do you think they gave any context or background, both sides of the story, how the statute, the stuff that journalists are supposed to do? Or do you think this mouthpiece, that would be a good one. Huey Lewis on the news is too hard to beat, but the mouthpiece, Tom Lewis. Oh my gosh, let's see. All right, get back to him.
News 13's Courtney Evans tells us the lawsuit Miller filed against the city has made residents angry.
Mexico Beach Mayor Michelle Miller is being recalled by residents. Committee Treasurer Mitch Coleman says the idea to recall Miller started after she sued the city council.
She said it was not going to cost the city or the taxpayers a dime, not 1 cent. That was her quote. Within a week after that announcement, the city's insurer said, we're not going to pay for a lawsuit. We can't do that. So right then we knew it was on the taxpayers, and she has refused to back away.
Monday night, about 100 residents stopped by Sunset Park to sign the petition. One resident saying she is tired of the way Miller has treated city employees.
All I know is she keeps attacking our city employees, and I'm not going to stand for it anymore. I'm over it. I think every time she does that in the next meeting, we're all just going to stand up and tell her to cease and desist, just like she told our council members.
I'm just let that sink in right there. All right, let's get back to it.
Former city council member says he signed the petition because he is against Miller's form of leadership.
Hadn't been good. It's destroying our city. It's tearing it down. We're a bunch of good people, and we're just trying to get it back now.
The committee has hired an attorney to assist them during the recall process. Some community members are donating money to help cover the legal fees.
It's quite comprehensive. It requires meeting certain deadlines and making sure you do things correctly, because there will be an audit of everything that we do. So it's important, if we want to be successful in this, is to get an attorney's advice.
Mitch, you lost today, buddy. Mitch, you guys filed a motion to dismiss. You told Judge Goodman in the court that he did not have the authority to consider whether or not your two claims against Mayor Miller were actually true. if there's any evidence at all, if your 2 allegations of misfeasance and malfeasance, do they follow statute or not? Well, you're going to find out, because I'm going to read to you the prevailing argument by Marie Maddox that was filed by the judge today. He denied their motion to dismiss because there's enough questions about whether or not the 2 allegations are true. And evidently, the judge, I don't think he would have dismissed I don't think he would have denied their dismissal if he believed he did not have the authority to sort of vet the legality and the veracity of the 2 charges. Mitch, it was a bad day. Your lawyer, Mitch, maybe you should have got a lawyer that knew what a sunshine law violation was and knew what the statutes were as they relate to the bogus allegations you guys made. Look how confident he is. We got Tom Lewis here. We got old Al Cathy counting his $500,000 he was paid by the city to his Ace Hardware store while he was mayor. You got all these citizens going up there with those skits, making those crazy allegations. Hey, you say, remember they were all going up with their little sheets of what they were supposed to say? Oh, I can't wait till the 8th of this month at the Bay County Courthouse, when the evidentiary hearings are pretty cool. Some of these people are going to go up under oath. I can't wait to hear what they have to say.
Courtney Evans reporting former Mayor Al Cathy was one of the people that signed the petition today to move on to the next step. They'll need at least 10% of the registered voters in Mexico Beach to sign that petition. And Mayor Miller declined to comment on the recall effort.
She did later on, though, and she'll have, I guess she'll comment as a witness in court in front of the judge under oath. So y'all are going to get your wish. Now, this is a big deal today, in my opinion, because here's what happened. You had the recall committee making 2 bogus allegations, or let's just say 2 allegations against the mayor, saying that this was grounds to recall her. Now, what we've been seeing, like with Judge Kelvin C. Wells in the Hoot Crawford case, for example. Do you remember him? This is Judge Wells right here. So in a criminal allegation against an attorney where he was, Hoot Crawford was charged and ultimately convicted because of the bum Judge Kelvin C. Wells. I call him a bum because he's a circuit court judge, but he doesn't want to have to do all the work. So he goes on Facebook the whole time he's presiding over trials, because if he's not on Facebook, and if he's not on Facebook or texting, I showed you that he falls asleep. So he wants an easier job. He wants to go back down to the county, just be a county judge. He's hoping to be appointed to be a county judge. But they charged Attorney Hoot Crawford with interfering with the lawful custody of a minor. So what do you think the defense for Hoot Crawford would be? Well, was their custody emergency shelter, was it a lawful order? That's your defense. If you are arrested, your defense is, hey, the probable cause wasn't there. There's no evidence. But Judge Kelvin C. Wells said he didn't want to be burdened, put in a position. These are his words. I don't want to be put in a position to rule on the legality of the shelter. Well, that's the whole damn crux of the argument. That's the whole case, Judge. So basically the judge said, look, if jury, you're not allowed to consider whether or not the state lawfully took that kid. All you are to consider is whether or not the attorney, the officer of the court, Hoot Crawford, did he hear the DCF worker say, we're sheltering the child, she's in danger, hey, I got run over. If the judge told the jury, if you think Hoot Crawford heard the DCF worker, then he's guilty. That's kind of what the recall committee is doing now on a civil level. They're saying Judge, don't consider whether or not the two allegations are true, whether the probable cause is true. It's just whether or not we say it. If we say it, let it be written, let it be done, then the voters got to decide. It's not your job, Judge. You don't have that authority. Well, today the judge said, we're going to have an evidentiary hearing on the 8th. All right, let me read to you the argument made by Michelle Miller and her attorney, Marie Maddox, which was found to be it was the prevailing argument. All right, I can see that I don't have one of them here. Let me grab it real quick. All right, here it is. You ready for this? Now, you may not be able to see it, and I can't zoom it in, but I'm going to read this to you. All right, so this is the case of Mayor Michelle Miller versus the recall committee. The chairman, his name is Donald Walker. Donald Walker is the chairman of the Mexico Beach Recall Committee. It's Michelle Miller, mayor, versus the recall committee. And the first page, it's 10 pages. It's really 9. But the first page says, the recall statute is, like all statutes, governed by the language contained therein. Courts have consistently held, this is Michelle Miller's argument that was upheld today, saying, no, you can't just dismiss this and say that they can say any old thing and overturn an election. That's not right. At least if there's going to be a recall election, the allegations have to be based in fact. They had to have happened. The judges doesn't have to rubber stamp it. So here's what they argued. Michelle Miller argued. The recall petition at issue in this case does not. It does not allege acts which constitute malfeasance or misfeasance. Worse still, the recall petition intentionally misrepresents facts in a thinly veiled effort to unlawfully use the recall statute to remove an elected official. Plaintiff, I'm not going to say plaintiff, I'm going to say the mayor and the recall committee, okay? So it's more clear. As Mayor Miller demonstrated in the lawsuit, there is no malfeasance because there is no sunshine law violation. Plain and simple. There is no malfeasance because the allegations do not show any act of misfeasance as a matter of law. Plain and simple. Therefore, the mayor has stated a claim for relief, and the motion to dismiss must be denied. So in a case like this, in a civil case like this, what has to be shown to the judge is that you have stated a claim. If you haven't stated a claim, then you can't prevail. So the point that she needs to make here is that she has stated a claim, and she has shown. Her claim is there's no malfeasance, there's no misfeasance. Now she has to prove it. Let's see. So there is a standard, a legal standard. And here it is. The defendant, I got to get to the second page. Here you go. So the defendant, the recall committee, did not state grounds for its motion to dismiss except insofar as it stated, quote, the allegations in the recall petition are legally sufficient. And the recall petition was timely filed. Each of these is more akin to an opposition to a motion to dismiss than a motion to dismiss. Nonetheless, Mayor Miller presumes that the recall committee is claiming that the lawsuit fails to state a claim upon which relief may be granted. The relief that Mayor Miller is seeking as the plaintiff is that the recall petition is thrown out because it is a lie. That's the relief that she's seeking, that the recall election does not happen because it's founded on 2 lies. So she has to prove that here. A motion to dismiss that the recall committee has put on her tests the legal sufficiency of a complaint, lawsuit, to state a cause of action and is intended to determine issues of ultimate fact, citing case law. And on a motion to dismiss, okay, from the recall committee, the trial court is limited to consideration of the allegations contained within the four corners of the complaint. That's what the recall committee is saying. In a ruling on a motion to dismiss, the court must construe the allegations in the light most favorable to the plaintiff, to the mayor. So the court must consider her claims in the light most favorable to her. Okay, so plaintiff has stated a claim. She has stated a claim upon which relief may be granted. Here's the argument. It asserts, the recall petition asserts two things. One, malfeasance based on an alleged violation of the Sunshine Law. And two, misfeasance based on alleged actions contrary to the City of Mexico Beach Ordinance 644. The mayor stated a claim that neither basis asserted in the recall satisfied statutory requirements. Okay, so there's, you can't have a recall if the claims are not true, right? If the allegations are not true. So let's go to page 3. Again, there are, let's see here. There are 10 pages, 9.5 really. All right, forgive me. I got to grab 3 here. All right, page 3. And this was upheld today by the judge. There you go. All right, 1, the first claim. Mayor Miller stated a claim that the recall petition did not assert the first claim malfeasance. Defendants' arguments, the recall committee's arguments regarding the Sunshine Act are particularly troubling and so specious as to border on being sanctionable. There is no dispute that a couple of weeks after, well, it was on April 30th, 2023, a couple of weeks after she was elected, Mayor Miller sent an email to members of the city council. There is also no dispute that nobody responded to it. Merriam-Webster defines an exchange as the act of giving or taking one thing in return for another. The recall committee knows full well that there was no exchange of emails. The email from Mayor Miller was unilateral. At no point has Mayor Miller ever admitted that there was an exchange of an email, nor could she ever do so, because it's undisputed that there was no exchange. Mayor Miller sent an email to the council members. No one responded. No one. Hence, there was no exchange. Not to put too fine a point on it, but had there been an exchange, then Mayor Miller and all of the city council members included in the exchange would have committed a potential Sunshine Act violation and engaged in potential malfeasance. Since the email was unilateral, no one responded, there cannot be a Sunshine violation as a matter of law. This case is clearly in line with the opinion of the Florida Attorney General, as found in both the City of Port Orange AG opinions and the 2023 Government in the Sunshine Manual. As the recall committee concedes, the 21-year-old City of Port Orange Attorney General opinion, which has likely not been revisited by the Attorney General since then, because it is considered so obvious to most practitioners that a unilateral email does not create a Sunshine Act violation. Now, the defendant, the recall committee, says emails violate Sunshine Law when they result in an exchange. They even say that in the petition to recall her. Result in the exchange of the council members' responses on subjects requiring council action. All right, so page 4. All right, let's get to page 4 here. I got to pull it up. All right, page 4. Similarly, the Government in the Sunshine Manual section cited by the recall committee is entitled, quote, Mayor meeting with individual city commissioner of city council member, They can't even write, these idiots. And states, quote, if the mayor is a member of the council or has a voice in decision-making through the power to break tie votes, meetings between the mayor and a member of the city council to discuss some matter which will come before the council are subject to the Sunshine Law. That comes from the latest government Sunshine Manual from the Attorney General's office. In case there was still any confusion that a meeting, like an exchange, requires participation of more than one person, case law says it's clear that requisite to the application of the Sunshine Law is a meeting of two or more public officials. That's case law. In addition, it is apparent that no meeting between two or more public officials is involved. Amply clarify that meeting means more than a unilateral correspondence. For those on the recall committee that are having trouble comprehending basic things, the recall committee failed to address either of these cases, even though both were cited by Michelle Miller, the mayor. The recall committee did, however, cite Thompson v. Napotnik. This was a 2006 case for its holding that the recall petition alleges that Thompson violated Florida law. You probably like the way that sounds, don't you? Namely, the provisions of the Florida Sunshine Law by engaging in an unauthorized meeting with other city commissioners regarding the closing of a local trailer. So there was a previous case where there was a meeting, and the recall committee cited that and said, look, Mayor Miller's guilty based on case law. In response, Mayor Miller points out the obvious, that case supports her position that a Sunshine Law violation does not occur when the alleged conduct is unilateral. Okay? All right, page 5. Likewise, the other case cited by the recall commission, Burton v. Oates, supports her position as well. Specifically, it is the failure to comply with the Florida Sunshine Law that can construe an act of malfeasance, where, as here, there is no failure of compliance with the Sunshine Law. There is no violation. Amazingly, in a blatant red herring argument, the recall committee urges the court to dismiss the lawsuit based on the recall committee's ill-founded and unsupported argument that Mayor Miller intended to violate the Sunshine Law. She intended to. Now, this is a non-starter. Either the Sunshine Act was violated or it was not. It was not. Here, it was not. Therefore, Mayor Miller cannot have engaged in malfeasance as alleged in the recall petition as a matter of law, and the petition must be dismissed. All right, and that cites, here comes some more case law. Our Supreme Court in Richard v. Tomlinson held that the statutory requirements are not met where the statement in the petition is nothing more than a conclusion or an opinion without any tangible basis in fact. That applies to any charge, any civil charge. In other words, you can't file a petition against somebody where there's no facts and it stand. This aggression will not stand, man. So Judge Makar his concurring opinion, quote, for similar reasons, petitions that make conclusory legal claims or are based on conduct that is lawful or not unlawful are facially invalid. For instance, a petition claiming that an official violated the public meetings laws about public meetings without a supporting statement of facts demonstrating how it's legally insufficient. Now, in Richard v. Tomlinson, It found that a petition is invalid where it constituted nothing more than a statement of a conclusion or opinion without any tangible basis in fact. Also, in Bent v. Ballantine, quote, the mere recital of a statutory ground without allegation of conduct constituting that ground is insufficient. Page 6. All right. To the extent that the recall committee would urge that the court is without the authority to look beyond the bare assertion that Mayor Miller exchanged emails, and therefore, because the recalls committee's recall petition used the word exchanged, it's sufficiently alleged an act of malfeasance. That argument is without support, and it's a violation of the duty of candor to the court. You got to be honest with the judge. You can't just make stuff up. Litigants have an obligation of candor to the court. Whereas here, it is undisputed that no one replied to the email. The defendant, the recall committee, must concede that the recall petition is false on its face. Remember, the judge, the judge upheld this today. Moreover, courts are clearly empowered to determine whether an allegation in a recall petition has any tangible basis in fact. Richard V. Tomlinson found that a petition is invalid where it constituted, quote, nothing more than the statement of a conclusion or opinion without any tangible basis in fact. For similar reasons, petitions that make conclusory legal claims or are based on conduct that is lawful or not unlawful are facially invalid. And it goes on and talks about how that's legally insufficient, the claim itself. Any suggestion that a court cannot take note of the evidence or ask the obvious question, was there actually an exchange? Merely because a recall commission misrepresented a unilateral email as an exchange in order to bring the communication within the Sunshine Law would be a gross distortion of the process. Courts are empowered to dismiss recall petitions that are not within the statute, and the recall committee cannot avoid dismissal by misrepresenting the undisputed facts. Now, the recall committee's error is founded on its representation that the fact, quote, that not council member, they mean to say no council member, the recall committee couldn't even write this very well. And it wasn't very long. All right, I'm going to talk like the recall committee. I'm going to read directly what they wrote. You ready? The fact that not council member responded in insignificant. All right, that's what they said. However, this assertion demonstrates, quote, a fundamental misunderstanding of the elements of the Sunshine Law. The recall committee doesn't know what the hell the Sunshine Law is or how it's violated. The fact that no one responded is not insignificant, Mitch. To the contrary, it's dispositive. That means this must be disposed of. That's what that means. Page 7. The recall committee's argument, its argument itself concedes the point. No one responded. Thus, there is and can be no Sunshine Law violation and therefore no malfeasance. Because on April 30th, 2023, this is what they say, she violated the Sunshine Law when she exchanged private electronic communications. God, she sounds like the damn FBI and U.S. attorneys going after Finch and Margot Anderson. Maybe they watched a lot of that and they thought, well, that's how the FBI argues. That's how the Justice Department argues. They just make stuff up. So Mitch and his crew said, let's just make stuff up. We're out here in Mexico Beach. Nobody's out here but us and $100 million in FEMA money. And this broad we got to get rid of. All right. So, as such, the mayor, Michelle Miller, stated a claim for relief. Get rid of this false recall vote. That's her claim for relief to the first allegation about the Sunshine Law. But there's a second allegation now. All right. There is a second allegation. And I'm going to share that second allegation and the prevailing argument with you right after this.
You want to look good? You want to feel good? Little John's Big and Tall is where it's at. Right across the street from Sky's Pizza Pie, 5700 North Davis Highway. You can find out more online at littlejohnsbigandtall.com. He's also a member of the iTex trading community, where your iTex dollars are welcome.
All right, we're on page 7 out of 9.5, basically. All right, so the second claim. All right, now let's look at that one. Mayor Miller stated a claim that the recall petition asserts misfeasance without a factual predicate. The recall committee argues that it is entitled to dismiss Mayor Miller's lawsuit as to misfeasance because the recall committee stated misfeasance with specificity. That's what they say. The allegation is not a conclusory allegation, and Mayor Miller is not entitled to argue that it's not true. Again, the recall committee is wrong. Defendant, the recall committee, is acting like the Wizard of Oz and asks the court not to look behind the curtain. You know, don't consider the probable cause. The recall committee wishes they had Judge the bum Kelvin C. Wells, who says, "No, we're not going to look at the probable cause. We're just going to say if you heard it, if they said it, it's true." That's what Judge Kelvin C. Wells said in the Hoot Crawford case. What a bum. All right, let's get back to this. We're on page 7. All right. So, the court's not the Wizard of Oz. The judge can look behind the curtain. Contrary to the recall committee's argument, Mayor Miller conflated nothing. Quote, the function of the court, of the reviewing court, is to determine whether the facts alleged in the recall petition are sufficient to establish a prima facie case under one or more of the 7 grounds for removal listed in the statute. And these facts do not meet that standard. The recall petition fails to name the contractor allegedly terminated by Mayor Miller and the contractor allegedly authorized by Mayor Miller to access city accounting systems without more information, including the name of the city employee whom Mayor Miller allegedly directed to engage in conduct at issue, the name of the allegedly fired contractor, and the name of the contractor allegedly granted access by Mayor Miller to the city accounting system. Without that information, the allegations are nothing more than the statement of a conclusion or opinion without any tangible basis in fact. Unbelievable. Unbelievable, really. But I mean, they're looking around going, hey, everybody else getting away with it. All right, page 8. There you go, page 8 right there. Even assuming that the nameless allegations were sufficient, let's just, for kicks and giggles, let's just say that that there were the names in there. The claims still fall short because the factual predicates established therein by the recall committee. Specifically, the recall committee claims that the act of misfeasance by Mayor Miller is her alleged violation of the City of Mexico Beach Ordinance 644 when she fired the contractor and authorized another contractor to access city systems. Ha! We got you, Mayor. We got you on Ordinance 644. To wit, they say that Mayor Michelle Miller should be recalled for misfeasance because, contrary to the City of Mexico Beach Ordinance 644, on July 27, 2023, she unilaterally directed a City of Mexico Beach employee to end services with one contractor and to authorize another contractor to access city accounting systems, an official act, and without city council approval, exceeding her authority as mayor. And by the way, I would have you know that the city attorney, Clint McCahill. Clint McCahill sat there and said, Mayor, if you do this, you're opening up yourself to some legal action. You can't do this unilaterally. Remember? You remember that, Clint? You were wrong. More bad legal advice, contrary to what you had said the year before. So what's Clint McCahill doing? He's out of there too. He's done. Everybody who was saying the mayor can't check the finances, they're jumping ship. They're gone. Except for old Iron Fist. Rich Wolf, the vice mayor, he's still there. He's got hopes. He's hanging on by a thread. Mayor Miller's out, then he could be the mayor. He's still trying to figure out why the press can videotape in the meetings. And then you got bad liability Jerry Smith, who's finding out what a bad liability all this really happens to be. I hope he's, please bring him up there. Oh, I want to see. He's funny, though, I got to say. He's got to get, he's like Mike Thomas. I want to see him talk to the judge. Judge, it was a bad liability, is what I'm saying. All right. So, therefore, from the plain face of the recall petition, the alleged basis for the allegation that Mayor Miller exceeded her authority as mayor and committed misfeasance is the alleged violation of the city ordinance. Hence, if the alleged conduct by Mayor Miller did not violate the city ordinance, she did not exceed her authority by virtue of said violation and did not commit misfeasance as alleged. See, here is the fatal flaw of the recall committee's argument. That ordinance that they're citing, 644, are you ready for this? It's a personnel policy. By its specific terms, it is applicable to employees. Mayor Miller is not an employee. Contractors are not employees. Can somebody fill in old Tom Lewis at WMBB and Mitch, the guy who goes on the TV and acts all confident? Okay, it doesn't apply. I don't know if y'all are just that dumb. I really don't know. I do suspect that Iron Fist is that dumb. I really do. But most of the other ones are just dishonest. So it goes on. So that is about employees and contractors, not a mayor. Therefore, even if Mayor Miller had fired a contractor or attempted to allow another contractor unauthorized access to city systems, which she denies, none of her conduct ran afoul or could run afoul of a policy that, quote, shall apply to and govern all employees of the City of Mexico Beach. Consequently, her conduct, even if, as alleged, was not and could not be contrary to the City of Mexico Beach Ordinance 644. And thus, her conduct was not and could not be misfeasance. And the second ground of the recall petition necessarily fails. And as such, Mayor Miller has stated a claim that and the recall committee's motion to dismiss her lawsuit must be denied. And it was today, by the way. The judge said, yeah, that's irrefutable, right? It is. All right, so page 9. And then after this, there's a half a page more. So Mayor Miller made this argument abundantly clear in her lawsuit at paragraphs 18 through 20. Yet the recall committee failed to address the argument. Frankly, there is no legitimate argument to be made in response. The alleged conduct does not violate the ordinance, which is the linchpin of the alleged violation, the misfeasance. that would support the recall petition. End of story. Thus, the plaintiff, Michelle Miller, has indeed stated a claim, and the recall committee's motion to dismiss her lawsuit must be denied. Now, instead of responding to the germane argument, all right, instead of doing that, the recall petition again argues that the judge is not empowered to demand evidence of the facts alleged in the recall commission. Your Honor, you can't see if we're telling the truth or not. You just have to, if we say it, then it's good to go. Well, that's not how it works. That might be how it works in Judge Wells's court, but that's not how it works in a court of law. This time, the recall committee couches the argument in terms of Mayor Miller attempts to argue that this allegation is simply untrue and there's no supporting evidence, no evidence to support it. In other words, she's just doing misinformation, Judge, and you don't have the power anyway to even consider it. Well, Judge Goodman wasn't having that. All right, so this is simply not correct. While it is not the court's role to determine if an official should be recalled, and this is a very important and nuanced point if you want to understand this for real. All right, it's not Judge Goodman's role to determine if an official should be recalled, but it is Judge Goodman's role to determine if the basis of the recall petition meets the statute. In other words, the judge is empowered to look behind the curtain and ask the obvious question. Is there any evidence to support the allegation in the recall petition? And the recall committee is not entitled to manufacture evidence or allegations in order to get a recall petition by the court, and the court is not forced to stand idly by while a recall statute is fraudulently used. Contrary to the argument of the recall committee, Mayor Miller is not attempting to litigate in court matters that should be instead debated by the public and decided by Mexico Beach voters at an upcoming recall election. Mayor Miller would happily defend all of her conduct to the Mexico Beach voters. But what Mayor Miller will not do, and no official should do, is accept a recall petition predicated entirely on bogus facts and unfounded legal conclusions. The stunt attempted here by the recall committee is the reason the recall statute permits court review and requires the recall committee to assert facts and valid basis for recall elections. Otherwise, elections have no finality if unscrupulous parties are free to file recall elections that they can't support with facts or law, right? That makes sense, right? All right, final page. This was upheld today by the judge. Now, the mayor clearly stated a claim that this court has the right to adjudicate, and the recall committee's motion to dismiss her lawsuit must be denied. The conclusion. The defendant to the recall committee's transparent motion to dismiss the lawsuit should be seen as what it is: an effort by the recall committee to remove a properly elected government official via a recall petition that fails to satisfy the statutory prerequisites. The recall committee cannot overcome the fatal defects in its motion to dismiss, and the recall committee creates a smoke and mirrors show with unfounded and unsupportable arguments regarding everything from Mayor Miller's intent to a wholly new and unprecedented limitation on the court's authority. Neither of the grounds for this is important too. Okay, hear this. Neither of those two grounds for the recall petition satisfy the statute. Where either fails, though,
If one of them fails to meet the statute, then the entire recall petition fails. So the court doesn't have to, in the upcoming evidentiary hearing on the 8th, which you're invited to, it's public, right here in Bay County. Can't wait to see it. Woo! Bring him under oath. Tell Judge Goodman what you did. Oh, I cannot wait for this. So if either of their claims are found to be invalid, the entire recall petition has to be thrown out according to case law. So whether the court relies on the failure to state malfeasance or misfeasance, the mayor stated a claim for relief and the defendant's motion to dismiss must be denied. We're going to trial, baby. Or to the evidentiary hearing, rather. The judge will decide anyway. All right, so wow. Have any of the news outlets told you this stuff? Hey, Tom Lewis, can you just send somebody out here and interview Mitch? So Mitch can tell everybody all the bad stuff that Mayor Miller did, and then Tom Lewis can go on there with a smirk and say, Michelle Miller. I mean, we're not having that.
This will not stand, This aggression will not stand, man.
Not today. And it is so good to see. I've been weary. I've been weary watching judges say, we're not going to question the foundation. We're not going to question the probable cause in a criminal case. And we're not going to question the veracity, the validity of the misfeasance and malfeasance and a recall. I'm so glad that something finally made sense in this era of non sequiturs. So anyway, I had to share that with you. WMBB will get around to it. They're again, Tom Lewis has egg. If you see him, that's egg on his face. All right, say, hey, Tom, what's on your face? and he'll say, well, what are you talking about? And you say, it looks like there's egg on your face, Tom. Maybe you need to go back out in the rain and wash it off.
In Panama City Beach, I'm Tom Lewis, News 13, Panhandle Strong.
Unbelievable. So I didn't think it was going to go to evidentiary hearing. I didn't. I thought the judge would either make a decision whether or not to dismiss the whole recall, or he would dismiss her lawsuit today. I thought that was going to happen. I think even he thought that was going to happen, because when he scheduled the evidentiary hearing, he had said, out of an abundance of caution, basically, we'll go ahead and schedule it. But the 8th is when the whole election starts, early voting. At least, I mean, it's probably started before. Are you mailing in votes yet? So, I mean, the judge has every right to be ticked off that he's got to make this decision this late in the game. And clearly he's smart, and it's not hard to figure out who did this, who made it late in the game. And I can't wait for that to happen. Anyway, I want to thank, of course, the Unknown Patriot for your support, sponsorship of the show. If you want to be a sponsor of the show, if you like what we're doing, and you say, Bernie, I do, but I don't want anybody to know, well, be an Unknown Patriot. And that way, nobody bothers you. But you sure help out the show, as do you patrons, everybody who throws a tip in the tip jar, as little as $5 a month. It's the best. Every show's worth $5. I mean, come on. God, that's a good deal. You can't buy anything better than that on the internet. You say, Bernie, you do it anyway. Without it, I couldn't. So thank you. It's easy. It's anonymous, and you can quit at any time. Patreon.com/Bernie Thompson. Thank you for those who support the show. And for those who donate via PayPal, as you'll see as I sign off. I'll be back soon. Wow. Who's going to the recall commit to the evidentiary hearing? It's in the Bay County courtroom, and there's going to be 2 hearings back to back. Michelle Miller's lawsuit against the city, saying they need to stop violating the charter and they need to start
following the charter, Judge Goodman's going to learn that FEMA reimbursements are being cut off from Mexico Beach because of the financial crisis that took place under Mayor Al Cathy and former city administrator Mario Gisbert. Remember Gisbert? Remember Senor Gisbert? And Doug Baber. And I'll tell you what, Chris Hubbard, I know that you're irresistible to the ladies. I still haven't shared that with you. Chris Hubbard says that the ladies who are mad at him, I swear to God, that they're just mad. He's my kind of guy. That they're just mad that he won't snuggle with them. They're just all mad at him because he chose another lady. The accountant, by the way. They're the only two people with keys to the finances. Oh, it's going to be good. That's the first thing that Judge Goodman's going to hear on the 8th. And then right after that, everybody go to lunch, come back, and he's going to have the evidentiary hearing for the recall committee lawsuit. Mayor Miller is incredible. If everybody and nobody can be, I've never seen anything like it. Nobody can be as tough, as tenacious, and as relentless, and as thick-skinned to the lies about her and her family. I've never seen anything like it. Rough around the edges, just learning everything, but she's determined to make sure that there's honest government and transparency. And boy, it's working.